The judge told us there would be no negotiation whatsoever once the trial started, and during the course of trial and testimony, there would be no sidebars whatsoever. You want to know why a judge told us this and why it was so important? Come join me for a moment as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and this took place during a medical malpractice trial in Brooklyn a number of years ago. So now we go ahead and meet with the judge before we actually start the trial. And the judge tells us very clearly, very straightforwardly, he says, listen, since you guys have not been able to resolve this case for the past 3 years, I'm not going to participate in any negotiations that the two of you want to have during the course of trial. Your time to negotiate is finished. Don't involve me in it if you're going to do it. That's number one. Then he said, listen, you guys know the rules. You're both experienced attorneys. There'll be no sidebars whatsoever during the course of this trial. You should know that a sidebar is when an attorney wants to speak to the judge privately during the course of testimony. Let's say there's a witness on the witness stand, and now someone is questioning the witness, and now an objection is raised. And before the attorney has an opportunity to voice that objection or to explain it in detail, now one of the lawyers says, Judge, could we have a sidebar? Meaning, can we talk to you privately on the side while the jury's still there, while the witness is still on the witness stand, so we can explain to you what it is we're trying to do or why we're making that objection. Many judges will allow the attorneys to go ahead and have that side conversation. However, this particular judge says absolutely not. You guys know the rules, you know what you have to do, you make your objection. If I agree, great. If I disagree, move on. This judge wanted no part in any side discussions. He wanted everything on the record so that if one side or the other has to appeal, now everything that was said in the courtroom is now on the record. You see, those sidebars, those side conversations are not recorded by the court stenographer. And now whatever agreement is reached, if the attorney wants to put it on the record, he has to ask the judge for permission to do so. So why do I share this quick story with you? I share it with you just to give you an insight and an understanding into what happened where one judge says, I'm not going to help you guys negotiate. The time for that is already long gone. And in fact, we did not negotiate at all during the course of that trial. The case went to verdict. And now the other thing was, during the course of trial, the judge did not take any sidebar conversations. We simply had everything recorded on the record, and now we went forward. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did in fact happen here in New York, and you have not yet started a lawsuit because you still have questions about something that happened to you here in New York, and you need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a great day.